Viewers, welcome back to the Personal Injury Law Show. We've been talking about superannuation, Kathy.
Good evening, Tony.
How are you?
I'm well, thank you. How are you?
Good.
Good evening,
Kathy,
nice
how are you?
viewers.
Nice seeing you
Nice
again.
to be here again. What an interesting topic about
Yeah,
superannuation.
it affects all of us.
It really does. It's amazing because we don't actually really consider the issues with policies and also what we've got available as rights, especially when we're injured. So it's been a great education.
Mr. Finch was very misunderstood, wasn't he?
Look, very, very peculiar case. In saying that, my understanding, Nuns, was that there's actually a little bit of a further hiccup that we haven't touched on tonight regarding the Finch case.
Look, yeah, there was, Kathy. Look, in this case, Mr. Finch made a representation to the super fund that his job with Qantas, which he worked at afterwards, he classified as a real job. And obviously, because the wording of the policy has got to do with your ability to be employed once again, that was a massive, I suppose, hiccup or road bump. And I think it's a big lesson to say that you need to see a lawyer early on, because if you make representations like that, that potentially can cost you a lot of money.
So, Nuncio, what you're saying is that he, trying to do it himself, mucked it up.
Exactly right.
And in fact, he had to go to the High Court.
Yeah, and look, and the fees involved in going to those, all the appeals, how much he saw out of that, I don't know, but
Well, to save a dollar, it cost himself thousands.
exactly right, Tony.
Yeah.
Well, in saying that as well, he also possibly could have had an adverse decision found against him because of these issues that were the initial cause.
Yep.
So, I mean, the good thing is that it worked in his favour.
I think we'll bring
Luckily.
Sarah back and talk about super another time, because we better get onto these questions, Kathy.
I know, we've got so much to talk about. We've got some really interesting questions this week, and I'm going to go to the first one, which is from James. And dear PI show, my 10-year-old son fell over in a friend's backyard and cut his knee on a protruding metal post on a retaining wall. After being admitted to hospital following infection to the knee, it was found that he had a rare fungal infection which damaged his tibia bone and growth plate. He has had 6 operations to date, with more to come. We do not know how much it will affect the growth of the leg until next year, when we have an idea as to how well the latest surgery has gone. At the very least, he will probably not enjoy a normal life in as far as normal sporting activities. What options are open to us in regard to liability of the house owner and also the hospital doctor who made a serious error in not receiving the pathology report when it was reported, and therefore cost my son valuable time in removing the infection? Now, what terrible set of circumstances, James. I'm so sorry to hear that. For a 10-year-old son to have undergone 6 operations,
It's awful.
it is absolutely awful. But Nuns, I'm going to pass this on to you, because it's quite a big question to answer for James.
Again, look, there's 2 aspects of this case, a potential public liability case and a medical negligence case, but I'd be going for the public liability case in this regard. And look, the homeowner will have insurance and you can sue against that, and obviously, look, an injury of this nature, there's potentially massive compensation.
Oh, look, I reckon it's a massive claim. It's under the Wrongs Act,
Yep.
so you only need the 5%. And,
Oh, look, I don't think that's going to be an issue.
it's not
at
an
this
issue.
stage, so.
I just think
6
that
operations.
there's going to be quite a few heads of damages here.
Yep.
You might have care into the future. You might have future cost of medical treatment, loss of income, perhaps.
It's difficult, 10-year-old, how do you assess his
He might have wanted to
damages
be
at
a
this
pilot.
stage?
You never know.
But may I ask as well, does age play a factor in this, given that he's 10 years old?
It will play a factor in when you should issue proceedings or take the next step, because as I said, you don't know how he's going to progress later on, but you've got time on your side. You've got 3 years from when he turns 18, so there's enough time.
One of the problems we've encountered in the past dealing with young people is, are they going to lose income in the future? But you might have some people that are obsessed about doing something when they're older. Like my youngest son, even from the age of 3, kept on saying planes, planes, planes. So now he's doing aviation.
Yeah.
So if you've got that situation where you've got someone that wanted to be a lawyer, doctor, this, that, whatever, and they won't be able to do it because of the injuries, you might have a loss of income there.
Oh, and
I know it's speculative, but you can argue
But
it.
that will be
huge.
determined in due course,
Yeah, look,
obviously.
he needs to see a lawyer, get advice and put on the right track.
It's a very good claim.
Oh, it's a very good claim.
Well, James, we do feel sorry for your son that he's had to endure this, but we hope that you seek legal advice and that the answer has helped you. But we're going to move on to our second viewer.
Can I just touch on something else?
Of
there, Kathy?
course, Tony.
Sometimes people get advice and they're not happy with the advice. It doesn't stop you from getting other advice because it's all a matter of opinion. Sorry, that's all I want to say.
No,
Yeah.
that's fine. Okay, well, the next question comes from John tonight, viewers. It's Dear PI Show. I changed jobs in April 09 to work for a sporting company and signed a general employment contract, including a 3-month probationary period. During this period, I suffered 2 strokes and also had heart surgery. I was sent back to work after 3 weeks and 2 days. And my manager 2 days later had me sign an extension of another 3 months probationary period. Over the next 3 weeks, I was continually told that as I had been given a clean bill of health, I had to be treated like a normal employee. I was pushed very hard and was unable to perform at the level I had previously. On the last day of what would have been my original 3-month probationary period, I was fired by my company, having been told I could not perform my duties. I've been involved in community cricket for 22 years and this was a dream job. Is there an opportunity to take action against the company or the hospital for the terrible diagnosis? I was only given the okay to work from my second urologist in June 2011. Now, Tony, this does follow on in the sense that it's a work cover and hospital or medical negligence.
It's a complex set of circumstances, this one. Look, you really do need advice. You've got to sit down and go through it very carefully. You know, because of the fact that he had his strokes and heart conditions at work during the course of employment, obviously you have to look at and see if work's a significant contributing factor, and that would give you the no-fault benefits for loss of income and also medical and associated treatment. And the fact that the employer says, oh, you got a clean bill of health, that doesn't exonerate them for the simple fact that it's pretty naive for an employer to think that someone that's been through that is going to have a clean bill of health and is pristine. So
And
they've got to be cautious. They've got to be careful where they treat him. So I think you need legal advice in this one. I'd definitely see a lawyer and get more facts.
Do you think there's a potential medical negligence case or unlikely?
Not likely. I think there's more of a case against the employer.
Okay.
There might be a potential common law.
Under work cover.
Under the work safety
And also in
legislation.
particular, if you do raise a work cover claim, just for general information, you an employer cannot actually terminate your employment for the 12-month period. There is a section in the legislation.
That's under the industrial law. So, but this is one you definitely have to get advice, but you'd have to link the strokes and heart to work. Significant contributing factor means it's got to be one of the factors. Yeah.
Okay, well, moving on to tonight's last question. This comes from Tom in Epic, and it's, hi guys. I sometimes hear people talking about structured settlements. Could you please explain what this is? Tony, please, could you enlighten us? What is structured settlements?
It's really hard to explain this one in short. What do you...
Look, it's rare in, I suppose, insurance matters, but sometimes you can come to out-of-court settlements and come to terms, and they can vary in terms of what you agree upon, but it's rare, Tony.
Yeah, it's rare.
We don't really
I
come to
haven't
that
seen one of these for a long time, actually.
Yeah. It's more in commercial matters than anything.
It's like a terms settlement. Yeah.
Okay.
We're getting towards the end of the show.
Well, we need to remind our viewers to keep writing into us. We love answering your questions and we want to see more of them, and hope that we can provide you sufficient answers. Please write in at info@thepishow.com and also catch up on earlier episodes at www.thepishow.com. And thank you again for having us this evening.
Thanks, Lucio. Thanks, Kathy. Thanks for watching, viewers. Stay safe. Stay tuned for next week too.